नमस्ते जी नमस्ते वेलकम टू कोर्टरूम बाय TLY। नाउ इमेजिन आपको किसी से इश्क हो जाए एंड देन सामने वाले के पेरेंट्स ना अलाउ करें उस व्यक्ति को जिससे आपका दिल का कनेक्शन बना है, और आप थोड़े से लीगली ओरिएंटेड व्यक्ति हैं। आपने डाल दी पिटिशन, रिट पिटिशन ऑफ हेबियस कॉर्पस की जरा कोर्ट जी देखें कि कहीं ये व्यक्ति इलीगल डिटेंशन में तो नहीं है, या ब्रिंग द बॉडी हियर की जरा कोर्ट में आके इनसे बातचीत करी जाए। ऐसे ही कुछ हुआ एक लैंडमार्क सुप्रीम कोर्ट जजमेंट में। हाउएवर जिनको दोनों को आपस में जो प्यार है वो सेम जेंडर के व्यक्ति, दैट्स द सो कॉल्ड ट्विस्ट इन द टेल। एंड जब दो व्यक्ति सेम जेंडर के हो जाते हैं, सोसाइटी स्टीरियोटाइप्स देम एंड देयर इज बेसिकली यू आर फाइटिंग इन अ वेरी अपहिल बैटल। सो उस पर सुप्रीम कोर्ट ने जो गाइडलाइंस दी हम लोग इस सेशन में डिस्कस करेंगे, एंड दिस हैज बिकम अ लैंडमार्क जजमेंट हियर pertaining to these cases. The writ petition came to be dismissed, but I'll take you through the facts of the case and then let us see how the Supreme Court A applied the law, and B what did it say and what guidelines did it issue to the other high courts, and which now basically are binding on everyone else thanks to Article 141 and doctrine of stare decisis. Alright, so habeas corpus, which is a pretty, one of the basic writs that a student of law gets to interact with is a habeas corpus. Of course, exempt from res judicata, always remember this, because habeas corpus deals with the issue of personal liberty. Which of the following writs is exempt from res judicata? Is habeas corpus. You can approach the court again if provided that the circumstances have changed, facts have altered, facts have been altered, or newer facts have emerged, whatever formulation of language you want to go in for. तो दिल आ गया है जी किसी पे. both women in this case are in an intimate relationship, but this woman is staying with her parents, and इनका जो केस है कि this female should stay with me, we are in a relationship and she is being held back by her parents. तो इसलिए फिर this woman approached the High Court with a habeas corpus petition. But since we are discussing landmark Supreme Court judgments, then what exactly are we doing in the Supreme Court? Let us try to decipher that. So for students of law and lawyers alike, 2024 INSC 228 is the neutral citation. Devu G Nair, Devu G Nair versus the State of Kerala. Just correct me if I'm wrong, but I think it's Devu as far as I recall. All right. So SLP lagi hui hai at the Supreme Court. This is Article 136 special leave petitions. You are straight away approaching the Supreme Court. It's a leave to appeal. Again, one of the cardinal concepts of law in which you can skip the hierarchy and straight away reach the Supreme Court. But this is not compulsory or mandatory. It's purely discretionary that you will get a hearing. Now, against SLB लगाई गई against interim orders that were passed by the Kerala High Court. And this is where the actual game begins. And Kerala High Court में ही थी writ petition. Excuse me, I just had to sneeze, therefore made a quick edit. Any which way. तो Kerala High Court में writ petition थी. Writ petition of habeas corpus was Kerala High Court. And now we come to the fact that X basically, this lady, इनका नाम X मतलब इनकी X नहीं, इनकी present है. X कभी X usually लोग एक दूसरे के बन जाते हैं, but अभी तो present में है. तो X is forcibly kept by parents and they are in an intimate relationship. तो ऐसा केरला हाई कोर्ट ने ऑर्डर करा कि DLS से डिस्ट्रिक्ट लीगल सर्विस अथॉरिटी के जो सेक्रेटरी साहब हैं या साहिबा हैं, she will go and record the statement of Miss X, and if she says, well, yes, that I am in illegal detention by my parents, then are not allowing me to move around, they're not allowing me in this relationship, well, let's get you out of there, right? Because you any which way are a major, you are an adult, etc. So if yes, you produce before the secretary, so यहाँ पे, and High Court would join in with via the video conference, and High Court would want to talk to her as to what exactly is the status, because even the courtrooms have to be very careful. These are these are matters that are very, very personal and private in nature. All right. Then after the interaction, the High Court said that please go in for a counseling session with a psychologist. Now this irked the Supreme Court. then why are you ordering a counseling session with a psychologist if the female in this case is happy in her sexual orientation and identification, and she is a fully mature adult who knows what to do with her life? How can you push her to counseling? Because this shows that perhaps you are against a female relationship, right? You are against that. However, that doesn't mean that it's incorrect, right? That is your subjective viewpoint. Everyone's entitled to an opinion, right? Each of us have our own biases of grooming. I'm not commenting whether what is correct or what is incorrect. I'm saying that everyone is free to an opinion, right? So SC then issued notice. So basically at this stage, we have filed an SLP and went to the Supreme Court that why do we need a counseling session with a psychologist? The Supreme Court issued notice and said that SCE committee member is to talk with X. So whoever the SCE committee member is there, she will talk with X along with the principal judge of the family high court. Both are in judicial services. And then the facts is, when they spoke to X said that she's a major, she has a master's in art, she has a mobile phone, she is free to move, she unrestrained by her parents. This is what she is saying. And yes, she said that I and the appellant, the person who is right now in front of the Supreme Court, is in we are in a relationship, an intimate relationship, a physical one most likely. So she has said, but the key point is that there is no restriction by her parents. So Mubarak ho, case to yahi khatam ho gaya. Petition has been dismissed because the Supreme Court said that we have no doubt, we have no occasion, or we have no chance that whether that this is, why should we doubt this? There's nothing for us to look into. However, since this had landed up in the Supreme Court, they said now, since this is an occasion to issue some guidelines to you. So the High Court, anyone who is going to be listening to such petitions, because there may be more in the future, when ordering psychological sessions, you should not order it, but when ordering, judges should keep their subjective point of views on one side and do not order these psychological sessions, because these psychological sessions, they can have a very deterrent effect on the person कि यार मैं पागल थोड़े ना हूँ, मतलब कहाँ भेज रहे हो मुझे, like क्यों, इसकी ज़रूरत क्या है? So identity and sexual orientation is outside the jurisdiction of the court. You can't tell beta no this is wrong, where are you doing, what are you doing, society है वो, ना आपका काम है कि आप law पे stick to करें. And then the LGBTQ plus counseling. So the plus in LGBTQ stands for, it's basically inclusive ki sare ke sare, whoever identifies with whatever is included in this term. Counseling can have a deterrent effect. You need to watch out when you are issuing psychological counseling. All right. So then, these were the major points out of the guidelines that they've given. If you are a lawyer who wishes to refer to this case for their pleadings, I've given you the citation, you can extract out more. The habeas corpus petitions will be heard on priority, right? So you need to give them priority in these cases. So habeas corpus petitions in which partners are coming forward कि नहीं जी इसको निकलवाओ वहाँ से, they need to be given priority. Precise details of relationship में courtrooms नहीं जाएंगे. You just need to see what exactly is the case. You will not enter into the domain of whether they could have entered into a relationship or not. In-camera interaction with judges to be made possible, that if you just do not wish to say anything in the open court and wish to directly interact with the judge, you can do so in the chamber. So that's called as an in-camera proceeding. Double check undue influence from all quarters, that is the police, the partner, the family, everyone else, because this is a sensitive matter. And judges' views not to be imposed, judges' personal views. See, every judge is a human being with their own set of preconceived notions, upbringing, biases, etc. So let it not affect the decision is what was given. And that's it. That's pretty much it to discuss with this case. On this channel, we are discussing the landmark Supreme Court judgments, and you can follow the playlist along. The TLOI in Courtroom by TLOI stands for Teaching Laws of India. We primarily prepare students for judicial services examinations. You can visit our website for any further details. You can explore the channel for many more sessions and lectures and so-called content that you will be contended with if you are a student of law or a lawyer or a prospective judge. Wishing you all the very best in whatever domain of your life. Wishing you all the best from life's sorrows and miseries that it usually tends to come with. Take care. Bye.